order. Prayer by the chaplain.
February 29th, 2012, the end of Black History Month. Anyone have a birthday today? All right, happy birthday. In the St. Paul Pioneer Press this morning, Mrs. Wilkie was 100, which means she's only 25 because she was born on February 29th. In light of that, Martin Luther King Jr. said, "Life's most persistent and urgent question is this: what are you doing for others?" There are multiple faith traditions and expressions in this chamber, so in the spirit of this chamber, let us pause for a prayer or reflection, as is your tradition. Gracious Spirit, we thank you today for those who have been elected to represent the people of our state. The issues are many, the resources are not finite, and I ask for wisdom and discernment for each member of this chamber, that decisions made here and the bills that they would pass on would unite our people in this state, provide for their needs, and be a reflection to our nation of the great state that we are and the great leaders that we have. Hardy in snow, strong in character, and above all, a true reflection of Dr. King's question: what are you doing for others? We also know that those called to leadership are family with one another. And so in the spirit of family, we uplift before you today Senator Kubley and his family in this difficult time for them as he is hospitalized once again. We pray that you would give them strength, comfort, and know that there are many that surround them with their thoughts this day. Amen.
Members, our guest chaplain for today is Reverend Ralph Olson from the Union Gospel Mission right here in St. Paul, Minnesota. Members, will you please remain standing and join me and Sarah on her 4th birthday as we recite the Pledge of Allegiance to the flag of the United States of America.
Pledge of allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you. Yep.
The clerk will take the roll. The clerk will close the roll.
Finger slip.
A quorum is present. Clerk will read the journal for the preceding day.
Journal of the House, 87th session, 2012, 78th day, St. Paul, Minnesota, Monday, February 27, 2012.
If there are no objections, further reading of the journal will be dispensed with, and the journal will stand as corrected by the chief clerk. Hearing no objections, the journal stands as corrected by the chief clerk. Reports of standing committees and divisions. Copy of this business has been placed on each member's desk. If there are no objections, the reports will be adopted. Hearing no objections, the reports are adopted. Second reading of House files.
Second reading, House File 1983.
Second reading.
Second reading, House File 2102.
Second reading.
Second reading, House File 2132.
Second reading.
Second reading, House File 2152.
Second reading.
Second reading, House File 2239.
Second reading.
Second reading, House File 2260.
Second reading.
Second reading, House File 2307.
Second reading.
Second reading, House File 2376.
Second reading.
Second reading, House File 2409.
Second reading.
Second reading, House File 2455.
Second reading.
Second reading, House File 2545.
Second reading. Introduction of House Files. The following House files have been offered for introduction today. The Chief Clerk will report these House files and give them their first reading.
Introduction and first reading of House Files 2561 through 2616.
First reading, House File 2561 through 2616. Messages from the Senate.
Message from the Senate. This is the Cornish motion. Mr. Speaker, I hereby announce the passage by the Senate of the following House file herewith returned as amended by the Senate, in which amendment the concurrence of the House is respectfully requested. House File 1467, an act relating to firearm. Signed, Kellar Ludeman, Secretary of the Senate. Cornish moves that the House concur in the Senate amendments to House Files 1467 and that the bill be repassed as amended by the Senate.
I call on the member from Blue Earth, Representative Cornish, who will explain the Senate amendments.
Mr. Speaker and members, House File 1467 went to the Senate and came back with one change. And the change is on the concurrence. And what it is, basically, is when the bill went over, when it talked about the presumptions you had under this bill, one stated that if you knew the person you were acting against was a peace officer, you wouldn't be entitled to the presumptions. The bill opened this up, and we went in the direction that the governor and the law enforcement were asking for, and now it says if the individual knows or had reason to know, and that's to give, basically, it widens it out where the person, even if you had reason to know that was a peace officer that you were taking action against, that you wouldn't be entitled to the presumption. And my wish is to concur with the Senate language and repass the bill.
Discussion. The member from Ramsey, Representative Paymar.
Thank you, Mr. Speaker, and I would ask the body to not concur. I think this bill is wrong. I think it's reckless. I think we should renounce it. I think we should reject it. We should refuse to concur. The main reason some people continue to want this bill is because they mistakenly believe that under current law they are required to flee their home if someone breaks in. This is not true. We already have the castle doctrine here in the state of Minnesota. Minnesota self-defense laws are clear. You can already use deadly force, and you are not required to retreat. And people can defend themselves in public too if they can't safely walk away or drive away. Mr. Speaker.
1 minute, Representative Paymar. Members, please. You can take your conversations to the alcove, or even better yet, to the retiring room so that the debate on the floor can be heard. Representative Paymar, you still have the floor.
Thank you, Mr. Speaker. This bill tries to solve a problem that frankly doesn't exist. There are no cases in recent years that I know of, at least in Minnesota, of a person being imprisoned for acting in self-defense. In fact, there were 2 cases back in 2006 where homeowners killed intruders and weren't charged. But this is what the bill does. It greatly expands the use of deadly force. It provides legal immunity for people who kill unarmed people if the shooter perceives he's being threatened. Not life-threatening, but punch-threatening. Do we really want to sanction killing someone to preempt a punch as a first resort? It also expands the use of deadly force against someone who enters your curtilage. This is a legalese word that the author has used. And what does that mean? That means yards, that means driveways, that means decks, that means porches, fenced-in areas, tents. In other states that have this shoot-first law, we are seeing the unfortunate results. A drunk who knocked at the wrong door. Another man shot through that door and killed him. Teenagers who entered the wrong yard, and an exchange student ends up dead. An armed neighbor complains about garbage and is killed by another neighbor. a man shot for walking his dog on another's property. None of these shooters were charged because of laws like this. So I guess the question for you is do we want someone inebriated, teachers playing pranks, or neighbors in conflict to die? Because that's what will happen with this bill. And what about the expansion of the law to public places? A shooter in Florida recently fired at a teenager running away down a public street and was not prosecuted under Florida's shoot first law. Under this bill, anyone who shoots in what he or she claims is self-defense is immune from prosecution, even if it's an innocent bystander. Now, the author of this bill claims that the Minnesota Police and Peace Officer Association, the Minnesota Chiefs of Police Association, the Minnesota Counties Attorneys Association, and the Minnesota Sheriff's Association don't speak for the law enforcement community. Well, if not, who does? You should have handouts from all of those agencies being passed out to you now who strongly oppose this bill. Last year, during the debate of this Shoot First bill, the author stated that the opponents of concealed carry laws in 2003 claimed that the sky would fall and that we would be like the Wild West if that bill passed. Well, the sky is still up there, but let's look at the history. I was here in 2003. Some of you were here in 2003. Proponents said hundreds of lives would be saved by the defensive use of firearms. In fact, the successful self-defense use of firearms since concealed carry is minuscule. Here are the facts that the author doesn't want you to hear. While I know that most concealed carry permit holders in Minnesota are law-abiding, concealed carry permit holders were convicted of over 800 crimes since 2003. Murder, assault, sexual assault, domestic assault, terroristic assaults. Ask the undercover police officer shot by a concealed carry permit holder during a road rage incident. Ask the family of a doormat at a restaurant who was shot multiple times by a drunk who bragged to be a concealed carry permit holder. Ask the woman who had a concealed carry gun pointed at her and her baby over a parking space. Another argument that proponents of concealed carry stated in 2003 was that people would not be reckless with their guns because there are laws limiting the use of deadly force. Well, if you pass this bill, how could that claim be true? Now, I don't predict that hundreds of people will suddenly start shooting people as a result of this bill, but some will, and some people will needlessly die. People will become emboldened, and the tragedies in other states will become the tragedies here. Finally, there's another part of this bill that's being overlooked. It is the part that forces Minnesota to recognize out-of-state permits to carry. In 2003, because of strong law enforcement opposition to concealed carry, certain changes were made to improve background checks for Minnesota's law. This bill would undermine all of that by allowing any out-of-state permit to be valid here, even online permits. Members, you should know, contrary to what the author has stated in the past, 391 people have been killed by concealed carry permit holders, including 11 police officers. These shooters were not killing in self-defense. The vast majority of these killings by concealed carry permit holders occurred in other states. So I would ask you, why would you adopt the lowest possible standards for concealed carry permit holders for this state? And why would you authorize such a thing when there is no database for our law enforcement to check if they stop a person who claims to have an out-of-state permit? Again, members, please reject this bill. Refuse to concur. It's reckless, and you will regret it.
Discussion to the motion. And members, if you could please take your conversations to the alcove, or better yet, the retiring room, so that the members could be heard on the floor. The member from Hennepin, Representative Loeffler, to the motion.
Thank you, Mr. Speaker. And members, I rise in opposition to this bill and concurring with the Senate amendments and putting it on final passage. This bill will result in unintended consequences that will be devastating to innocent lives. and we've seen it over and over again in my community. Not all people who possess weapons are expert marksmen, not especially when they're under threat or feel under threat or are nervous or in circumstances in which they may not be thinking about the people around them and the people in the buildings around them. And I must say, our community has seen tragedy after tragedy when these people who are not expert marksmen hit the wrong person, the wrong house, the unintended person. And the most tragic of these are the children. It was in 2002 that we first woke up, I think, as a community and as a state to this, when Taisha Edwards, a 12-year-old girl sitting at her dining room table doing her homework at 3 o'clock in the afternoon. A bullet shot, not intended for her, not intended for her house or anyone associated with it, went through and shot her dead. Then it happened again when a young girl, also 12, Guadalupe Galins Hernandez, was just walking down the street with friends. The normal thing you do when you're in a neighborhood. And she was shot in the neck. Her life has totally changed. She is paralyzed for the rest of her life. Tragedy again struck another innocent victim this last year when Terrell Mize Jr., whose mother knew he lived in a risky neighborhood. He was just 3 years of age. They heard gunshots. The mother had taught her children to run up the stairs and be in an enclosed closet so they weren't near a window when gunfire erupted in their neighborhood. Whether it was target practice, it was somebody shooting at another individual, we won't ever really know for sure. But her 3-year-old son, Terrell, was running up the stairs to safety and was shot in the head and died. There are many, many stories of innocent victims. Only the children get the heart-rending stories of suffering. Last year, HCMC treated 122 gunshot wounds in my community. We live in houses 10 feet from the neighbors. We do not need to feel at risk because someone feels threatened by something going on in our community and their bullets go far from their intended targets. I urge you to join me in protecting the innocent victims and stopping this bill as it moves forward. Thank you.
Discussion. Members, please. If you could take your conversations to the alcoves, or even better yet, to the retiring room so that the debate on the floor can be heard. The members who are listening to the debate and the audience would appreciate your consideration. Discussion to the motion. The member from Ramsey, Representative Moran. Oh, I'm sorry. Discussion. The member from Blue Earth, Representative Cornish.
Mr. Speaker and members, I'd just like to restate that I'd like you to vote for the repassage, concurrence and eventual repassage of this. I'm kind of confused here as to these stories and why they've come up now, because zero of them had anything to do with the Castle Doctrine and its application of the stories that you heard on the floor. The bill as it stands before you, we had a good debate last year. We passed it with 79 votes. It's come back even better, and I just appreciate your vote. Thank you.
The member from Beltrami, Representative Purcell, to the motion.
Thank you, Mr. Speaker. Representative Cornish, I just have a question here. I have asked folks around my district what they thought about this. As you may recall, I voted for the bill last year. And I did so with some trepidation, knowing that law enforcement didn't particularly like the bill. And I take very seriously my partnership with law enforcement. But I had another question that was asked to me out in my district, and it came from some business people, actually. And it has to do with the current law, the current statute, 624.714 subdivision 17, posting trespass. So we're talking about the permit to carry. And the particular language that was put into law banning guns on the premises of a business, a private entity that doesn't want to have firearms carried in their premises. Does this bill in any way impact those private property rights that we already have codified?
Representative Cornish will yield. The member from Blue Earth, Representative Cornish.
Mr. Speaker and Representative Purcell, no, the permit to carry legislation, hang on, tangled up. The present permit to carry legislation that you spoke of is untouched by this document or this proposal. All of the provisions of the permit to carry, the trespass, the posting for businesses would still apply as before.
Seeing no further discussion, all those in favor of the motion to concur signify by saying aye. Aye. Opposed, nay. Opposed. The motion prevails. The clerk will give the bill its third reading.
Third reading, House File 1467, as amended by the Senate.
Third reading. Member from Hennepin, Representative Mullery.
Thank you, Mr. Speaker and members. First, I'll talk about the great expansion in the permits under this. This would allow any permit from any other state or any other governmental body, and I just checked with research. So if you have a permit from Somalia, from Iran, wherever, you can now carry it in Minnesota under this bill. Further, it takes away the present requirement of checking on mental health. So no longer would you have to check before giving a permit to see what kinds of mental illness, schizophrenia, different things that they may have active and not treated by medicines. That would all, you could then have a permit under this. And I've checked this out with research on that. So those are true. And members in committee last year, just if we waived the Minnesota requirement and went by the federal, which others have, in 1 year in Bloomington there were 170 people that would have gotten permits who had serious mental health problems or had been convicted of domestic assault. So this is an enormous waiver when we are allowing people with permits from Somalia and Iran and wherever else to come into Minnesota and carry guns. That should speak to itself of how badly drafted this bill is. But still, the most important part, according to the prosecutors I've talked to, and I think probably nobody in here has handled and prosecuted as many cases as the top prosecutors in the state that I talked to about this. And they say the one big problem above all else is it now just allows the person to claim that they believed that somebody was going to commit action against them or against another person, or they believed somebody was going to steal a felony, commit a felony against it. So if a kid, his ball went over the fence and somebody goes jumping, the kid goes jumping over the fence to get the ball, he can now be killed. Do we really want that? I asked the prosecutors for my neighborhood. Representative Loeffler talked about incidents right in my neighborhood. I was at the ceremony, the morning ceremony for the little child of 3 years old who was shot going up the stairs to supposedly escape it. We have a lot of problems with shooting. In this case, if a gang member claims that they thought another gang member was going to cause harm to somebody, they can shoot him, and the prosecutor has to prove what the intent was in the mind of the other person, which the prosecutors claim is impossible. So, members, I hope that you can vote this down. It is really a dangerous step forward, or step backward for Minnesota, and I urge a no vote.
The member from Scott, Representative Biskins, to the motion.
Well, thank you, Mr. Speaker. Mr. Speaker, would the member from Minneapolis yield to a question?
He will yield. Representative Biskins.
Thank you, Mr. Speaker. Representative, you just stood up here on the House floor and you made the case for why we shouldn't vote for this bill by saying that if a person who has a concealed carry permit in Somalia or Iran came to Minnesota, we'd now have to allow it. Representative, could you tell me what is the criteria of an ordinary citizen in Somalia to attain a concealed carry permit? Because I'm wondering, I don't know if this is a good thing or a bad thing. The criteria may be more strict than it is here in Minnesota. So, Representative, could you tell me what the criteria is to get a concealed carry permit in Somalia? And then, rather than me asking you again, I'd also like to know what is the criteria in Iran, Representative.
Member from Hennepin, Representative Mullery.
Thank you, Mr. Speaker. Representative Biskins, and by the way, it's as you know, it's the member from Hennepin, not the member from Minneapolis. But the fact is, I have not researched what the criteria is in Somalia to get a permit, nor in Iran.
The member from Scott, Representative Biskins.
Well, thank you then, Mr. Speaker. If the member from the county of Hennepin, the city of Minneapolis, would yield to one other question.
He will yield, Representative Biskins.
Thank you. Representative, can you stand up here on the House floor and tell me for certain that an ordinary citizen in Somalia or in Iran can apply for and receive a concealed carry permit, or were we just blowing smoke on that one as well?
Member from Hennepin, Representative Mullery.
Thank you, Mr. Speaker. No, Representative Biskins, you're the one that's blowing smoke by passing a bill that you don't understand what the consequences are. If you don't know that no other government in the world has standards that are extremely low, then why are you passing a bill that says that they can come here and you're subjecting the people of Minnesota to those standards that don't exist maybe?
Member from Scott, Representative Biskins.
Well, thank you, Mr. Speaker and members. I hope you heard that. All right? This is a common tool used by people who want to fearmonger, who want to create some big boogeyman in the closet, because you know what? They believe that they were sent here and given by the good Lord some divine power to know and understand what is better for the people of Minnesota than the people of Minnesota do themselves. So rather than make a logical, reasoned argument, they create a big boogeyman. And we use things like, well, a person from Somalia or a person from Iran can come here with a concealed carry permit. Now we have to allow them. Of course, he doesn't even know if such a thing exists, but that makes for a big boogeyman, doesn't it? One would say it borders on a racist boogeyman, but I'm not going down that road.
Mr. Speaker.
I think we have to stick to the facts.
Representative Biskins, 1 minute, please.
Yes.
Member from Olmsted, Representative Liebling. For what purpose do you rise?
Thank you, Mr. Speaker. I rise to a point of order under Mason's Section 125 124, I beg your pardon, about arraigning the motives of a member.
State your point of order, Representative Liebling.
Yeah, Mr. Speaker, a moment ago, Representative Biskins was, I believe, arraigning the motives of Representative Mullery here about why he's opposing this bill and talking about his wanting to, having all kinds of motives about telling everybody what they should do and so on, and I believe that that violates the spirit of Masons.
Thank you, Representative Liebling. And members, we have not referenced Section 124 yet this year. Representative Mullery, Representative Biskins, if you could please, I will defer a ruling, Representative Liebling, at this time, but if we could stick to the repassage of the concurrence, it would be better served by the members of the body. Representative Biskins, you still have the floor. Representative Liebling.
Well, thank you, Mr. Speaker and members. I defy anyone who stands up on this House floor and talks to a piece of legislation to do so without having a motive to do so, because I'd love to see that one. We all stand up here on the House floor and we have motives. And in a debate, when people make statements, they either back the statement up with fact or they stand ready to be challenged on the statement. Mr. Speaker, I'm speaking to fact on what was said here on the House floor with a motive to influence the votes of the members of this body. That was the motive for what was said on the House floor. I'm challenging that to say either back it up with fact or be ready to be challenged by it. Members, it's our responsibility as representatives of the people we were sent here to speak for that we do not let falsehoods be brought into the debate. If we sit on our hands, then we get what we deserve, and the people of Minnesota deserve much better than that.
Mr. Speaker,
Discussion to the repassage. A member from Hennepin, Representative Mullery.
Mr. Speaker, he has gone too far now. He is alleging that I stated falsehoods, and that is totally improper, and I'd ask a ruling by the Speaker on that issue. I think it's no question that that's out of line.
Representative Mullery, again, Section 124 was referenced. I don't believe you are asking for a point. You did ask for a ruling, and I will defer a ruling again. Keeping to the bill and to the repassage of the concurrence is what we're on right now. Representative Mullery, I will defer a ruling at this time. Discussion to the motion. Seeing no further discussion, the clerk will take the roll on the motion.
On the bill.
On the bill. My apologies.
Yeah, we got him.
The clerk will close the roll. Representative Mariani votes no. Representative Mahoney votes no. There being 85 ayes and 47 nays, the bill is repassed as amended by the Senate and its title agreed to. Reports from the Committee on Rules and Legislative Administration.
Report from the Committee on Rules and Legislative Administration. Dean for the Committee on Rules and Legislative Administration, pursuant to Rule 121, designates the following bills to be placed on the calendar for today for Wednesday, February 29, 2012. House file numbers 1879, 1829, Senate file numbers 1371, 1240, House file numbers 2046, 1043, 1835, 2246, 545, 1560, 1850, and 1812. Senate file 134, House file numbers 158, 2158, and 1903.
Calendar for the day. The first bill on the calendar for the day is House File 1879. The clerk will report the bill.
House File 1879 on the calendar for the day, an act relating to public safety.
Call the member from Blue Earth, Representative Cornish, to present your bill.
Mr. Speaker and members, House File 1879 addresses the following. Back some time ago, we had two groups of people, peace officers and correctional officers, that if you killed one of them, they'd be murder in the first degree, an enhanced penalty. This bill was brought to us by the County Attorneys Association and is supported by the Sheriff's Association, and basically adds prosecuting attorney to the mix. So for the purposes of this law, as you see, House File 1879, it modifies 609.185, murder in the first degree, and adds prosecuting attorneys to the other ones. This bill naturally, I think some people talked about it before, but it was brought to light, more attention by the assault on the attorney up in Cook County. And it seems to be a popular bill with no opposition that I know of. It's supported by the county attorneys and the sheriff, and I would stand for any questions.
Discussion. The member from Olmsted, Representative Liebling, to the bill.
Thank you, Mr. Speaker. Would Representative Cornish yield to a question?
He will yield. Representative Liebling.
Thank you, Mr. Speaker. Representative Cornish, I'm not sure that it helps protect it. But while we're doing this, I'm just wondering why you're not protecting defense lawyers or other lawyers who are also in the courtroom on official business. You know, sometimes people come into these courthouses and very unprotected courthouses, I may say, where nobody's screening for weapons. People can walk in, and sometimes you get people who are there as victims who may be angry at a defense lawyer, or who are there on a civil case who may be there angry at a lawyer who's not a prosecuting attorney. So, you know, I understand surely that we need to try to discourage people from shooting up courthouses and those who are working in courthouses, but I'm wondering why you're not extending the same protection to those other attorneys and, for that matter, to the other court personnel.
The gentleman from Blue Earth.
Mr. Speaker and Representative Liebling, the short answer, and not to be flippant, is that they never brought a bill to me. The County Attorneys Association brought the bill, and they were asked about that, but they didn't want to spread the net so large. If you include group after group, naturally you're going to end up also in a fiscal note, a lot more people affected. And they brought the bill, they wrote it. I agreed to carry it, and I did have a few questions from other court personnel about it, and I gave them the same answer. But the short story is they never brought a bill forward. They could in the future try it, and if somebody would carry it, I don't know what kind of a success it would have, but that's the reason.
The lady from Olmsted.
Well, thank you, Representative Cornish. I mean, okay, I can understand nobody brought it forward, but my goodness, if we're worried about a fiscal note, what does that say? That would be, what a terrible thing that would be to worry about here. We wouldn't protect a defense lawyer, but we'd protect a prosecutor because we're worried about a fiscal note? Boy, I don't like that answer very much. You know, members, I don't see anything wrong with this bill. I'm going to vote for it, but I have to say, this is really pretty sad. This is sad because what we ought to be doing is spending some money to make our courthouses secure. And instead, what are we getting today? We're opening up the door to more gun violence, and we're saying, oh, here, we're going to up the penalty if you shoot up a courtroom and happen to kill the wrong person. Boy, that's a lot of protection you're giving your police officers and your county attorneys and the other people, your judges. This is really poor, and I hope that as we go forward, I hope we can do better than this, because the people that work in our courts, this is where you're getting the most disturbed people that go to court at the worst time of their lives, and you're letting people walk into courthouses with guns, and the best you can do is say, if you kill a prosecuting attorney, we're going to make the penalty higher. Well, I don't think that's very good, members.
The clerk will give the bill its third reading.
Third reading, House File 1879.
Third reading. Any further discussion? The clerk will take the roll. The clerk will close the roll. There being 130 ayes and 1 nay, the bill is passed and its title agreed to. The next item on the calendar for the day, the clerk will report the bill.
House File 1829 on the calendar for today, an act relating to public safety.
The gentleman from Blue Earth, Representative Cornish.
Mr. Speaker and members, I'm going to try to explain this in the basic layman's terms because it's a short bill, but it can be complicated to understand. This bill actually, some people think, was a knee-jerk reaction about the prosecutor that was shot up in Cook County. But actually, this bill came to me from my county attorney, Ross Arneson in Blue Earth County, 5 days before this incident happened. And he was talking about the increased amount of disrespect and violence shown in the courts statewide, and that he thought that the county attorneys and prosecutors, the county attorney was at risk for assault or death. And so he forwarded this bill, and as we were going over it and getting other county attorneys involved in the discussion, unfortunately the tragedy occurred up in Cook County, where a man came into the courthouse, received an adverse verdict that he didn't like, went out to the car, got a gun, came back in and went into the county attorney's office and shot him. While the county attorney was testifying on the bill in our hearing, he still had the slug from the gun in his leg that he still had to get removed yet. So it's kind of moving testimony. At any rate, what this bill doesn't do is open it up wide open in court for anybody to have a firearm. The reason, the need for this legislation is because currently there's a law in the books that said a political subdivision employee cannot carry while on duty. What we've done here is taken out, given the exemption to this statute, to the county attorney and assistant county attorney. But the protection or more control that we've put in is the county attorney can still trump and restrict the assistant county attorneys from having it. So if there's a county attorney that doesn't want to carry, he doesn't have to, or she, and if they don't want anybody in their staff to carry an assistant county attorney, they can prohibit them from doing it. Not all county attorneys, maybe not even the majority, will exercise this privilege under this legislation. Another question that we got is, what will the judges think about this? Well, believe it or not, there's a lot of judges that are packing heat under their robes and approve of this also for the county attorney. And the county attorneys will be able to carry, they'll be able to trump the assistant county attorneys. The judge will be able to control the whole works. He can say, or she, not in my courtroom, you don't. This doesn't affect the judge's capability to restrict and keep firearms out of the courtroom except for the bailiff if he or she wants. So it's controversial to some, not to me, of course, and it allows the county attorney to protect themselves. Another thing you ask is, what is the courtroom? What will the boundaries be? That's up to each individual judge, how he or she diagrams what they think is a courtroom or the courtroom complex. If they include the administration, if it's a courthouse with offices in and they consider it the whole courthouse, that'll be pretty much up to the judge to say who can carry in and out of the courtroom. So that's basically the bill that allows the county attorneys to carry while on duty, and in the parking lot, in the hallways, the elevators, going to and fro, so that they can have a sense more of protection or peace of mind. Thank you.
The clerk will give the bill its third reading.
Third reading, House File 1829.
Third reading. The gentleman from Ramsey, Representative Johnson.
Thank you, Mr. Speaker. Members, I think the main thing I'd say about this bill is that the concern about security in county courthouses throughout the state remains a very serious problem, particularly the inconsistency that we see throughout the state of Minnesota as far as providing the kind of security that not only the people who work in the courthouses need, but also the people that go to court to get their cases heard. So this bill in no way deals or addresses that issue in any kind of manner. It's an issue we're going to have to keep paying attention to at the state of Minnesota and deal with and tackle. That's about it.
Another gentleman from Ramsey, Representative Lesh.
Thank you, Mr. Speaker. Would Representative Cornish yield to a question?
He will yield. Representative Lesh.
Thank you, Mr. Speaker. Representative Cornish, I noticed that in the last bill, you expressly included in the definitions of prosecutor city attorneys, the job that I hold. But in this bill, it's excluded. So I guess I'm wondering, where's the love?
The gentleman from Blue Earth.
Mr. Speaker and Representative Lesh, once again, the county attorneys wrote this, and it was their opinion, in some others, that the county attorneys are the prosecutors of the more serious crimes and the more threat. And I suppose the city attorney could argue back and forth with prosecuting attorneys over that fact. But once again, the city attorneys didn't come and present or ask for a bill, and the prosecuting attorneys, the County Attorneys Association wrote this, and it was supported by the Sheriff's Association and the County Attorneys Association. So that's the best answer I could give you. A future bill could include them, but they wanted to keep it clean with this language for now.
The gentleman from Ramsey.
Thank you, Mr. Speaker. Well, I appreciate the answer, Representative Cornish. I guess my concern is how this was brought and thought out. As a prosecutor for 12 years now, if I had to make a guess, I'd say about a third of the people I prosecute are going to get a conviction if they get convicted, and they'll have a probation violation, and the judge will pack them on a previous crime or felony that they have. So in many cases, the cases I prosecute, while the maximum time they can get in jail for me is a year, they're going to get packed on a probation violation and go to jail for 5, 6, 7 years, whatever it is the original offense that they offended on, which in many cases for felonies is not the case, because if you're outside the box and the sentencing guidelines don't call for you to get any time, you're not going to go to jail at all. So I think there's a valid reason for that consideration. That said, as a prosecutor, I know that if someone's going to be stalking me and looking to get me, they know where to find me, and that's going to be in the courtroom. Unless they want to try to stalk me in other places, good luck. But they'll know how to find me in the courtroom, and that's a place where it's going to be completely up to the judge anyway.
Further discussion to the bill. The clerk will take the roll. Members, please vote. The clerk will close the roll. There being 116 ayes and 15 nays, the bill is passed and its title agreed to. The next bill on the calendar for the day is Senate File 1371. The clerk will report the bill.
Senate File 1371 on the calendar for today, an act relating to public safety.
The gentleman from Morrison.
Thank you, Mr. Speaker. Mr. Speaker and members, Senate File 1371 allows law enforcement agencies an additional option in regards to forfeited firearms. It allows them the ability to sell to a licensed firearm, federally licensed firearm dealer. Current statute allows them two options, which are to destroy the weapon or to use for training purposes, and Senate File 1371 will give them this extra option.
The clerk will give the bill its third reading.
Third reading, Senate File 1371.
Third reading. Any further discussion? The clerk will take the roll on the bill. The clerk will close the roll. There being 123 ayes and 9 nays, the bill is passed and its title agreed to. The next bill on the calendar for the day is Senate File 1240. The clerk will report the bill.
Senate File 1240 on the calendar for the day, the first engrossment, an act relating to public safety.
The gentleman from Blue Earth, Representative Cornish.
Mr. Speaker and members, sometime back you remember a big hullabaloo that took place, the Metro Gang Strike Force and all of the activity in the media on the forfeiture, seizure, confiscation of property, and after that all the discussions took place. There was a work group called the 2725, and they met many meetings, long period of time, law enforcement and prosecutors and citizens representatives and professors trying to come to some solution for this whole mess. Well, they didn't really agree on much or accomplish a heck of a lot, except one thing that came out of it that was good was the forfeiture law changes. What you see before you, Senate File 1240, we're dealing with the Senate file, the forfeiture law changes. The Institute for Justice, the public defender, the county attorneys, law enforcement, everybody was in agreement on this. There's still a couple of people that don't agree, but the vast majority of this whole work group agreed on these changes. And you've probably got this in front of you, but I hate to read anything. I'd rather just speak it out, but there's so many changes. The forfeiture law changes, it was amended in judiciary to compare changes made in the Senate and the effective date and the ability of local law enforcement to determine the languages and the notices it needs to be printed in. It revamps the forfeiture laws to comply with changes made last session. According to drugs, it requires the issuance of a receipt when a vehicle is seized. It exempts off-road vehicles being held for investigative purpose from the ability of the owner to reacquire the vehicle by posting security or bond. Basically, it makes changes in favor of the people that the thing is being, the property is being taken from. They define prosecuting attorney as an attorney who's responsible for prosecuting the offense. There's time limits. There's notices. Pretty much takes care of a lot of the concerns about this portion of the trouble that you heard back on some time ago. And there are a couple of controversial aspects that somebody will probably address, but that is Association of Criminal Defense Attorneys. I forgot to mention those, and the county attorneys. So it's a pretty far-reaching cooperative effort approved by the whole group that I would appreciate your vote. Thank you.
There is an amendment at the desk. The clerk will report the amendment.
Cornish moving to amend Senate File 1240 to first engrossment as follows. The amendment is coded A1.
The gentleman from Blue Earth.
Mr. Speaker and members, if Representative Hillstrom would like to explain this amendment, it's actually hers, the 240A1 amendment and what it does to the bill. Thank you.
Representative Hillstrom.
Thank you, Mr. Speaker. Representative Cornish, thank you for offering this amendment. Members, I brought up this concern in committee. Sometimes people get stays of adjudication. They admit that they're guilty of the crime, but they get a stay of adjudication or the conviction doesn't go on their record. Representative Cornish's bill would have said that the forfeiture has to be on hold until the end or the crime was adjudicated. Well, in cases where you have a stay of adjudication, you might have 5 years or 10 years. And I think what he really meant was at the end of the criminal proceeding, not at the end of the adjudication. So this really is a technical amendment to get him to where he wants to be, and this is the language that's required to get him there.
Discussion to the Cornish amendment. The gentleman from Blue Earth.
Members, I would just appreciate a vote on the yes on the amendment or an aye, and thanks to Representative Hillstrom for the idea and the amendment.
Further discussion to the Cornish amendment. Seeing none, all in favor say aye. Aye. Opposed? The motion prevails. The amendment is adopted. There is an amendment at the desk. The clerk will report the amendment.
Liebling and others moving to amend Senate File 1240 to first engrossment as follows. The amendment is coded RA 12-326.
The lady from Olmsted, Representative Liebling.
Thank you, Mr. Speaker and members. Members, generally speaking, I like this bill. I think it does make some improvements, but there is one area where it takes a big step backwards. And that is that up until now, when a person had their property forfeited, in other words, when law enforcement took their property from them, they had to give them a notice telling the person that they had the burden to go and get their property back if they had a right to it, and telling them that they had to do exactly certain steps in order to get their property back. That notice had not only English but Spanish and Hmong on the notice. Now, what this bill is doing is removing all the requirement for languages. The original bill also added Somali, because you can imagine that when a person is getting their property seized, remember, government is grabbing your property. And it is now on you to take steps to get that property back. But now, under this bill, you will not be told in Spanish or Hmong or Somali what your rights are. It will be only in English. Members, there was testimony in committee that this could possibly open up some lawsuits even for violation of due process, when people's property is being taken by government and they are not even told in a language they can understand what steps they need to take to get it back. So all this amendment does is it puts back the original language that was in the bill. As far as Hmong and Spanish, that's the way we've been doing things for a long, long time. What the bill does is take that away and leaves it up to individual law enforcement agencies to decide whether to put languages on their form. This is ridiculous. It puts a burden on them that's unnecessary. It means that forms will no longer be centrally printed. Every agency is going to have to make a decision and print their own forms. This is ridiculous. If we're going to allow government to take people's property, to grab their property, whether or not they've done anything wrong, then we need to make sure that people at least know what their rights are. So, Mr. Chair, I would like a roll call on this amendment.
Roll call being requested. Are there 10 hands? Seeing 10 hands, there will be a roll call. The lady from Olmsted.
Thank you, Mr. Chair.
Discussion to the 326 amendment. The gentleman from Blue Earth.
Well, Mr. Speaker and members, I would ask you to oppose this amendment. This amendment was put on in the Senate, and after a long period of discussion, and Senator Latz, I think, even okayed this amendment, who is probably on the opposite end of some there on the spectrum of who is for and against the bill to begin with, and it was a compromise. The reason I think probably for it is they wanted to believe in local control, and why should we pick out these languages? Representative Liebling might have been right that it's been there for a long, long time, but that's probably why they need to be changed. Why would you have a mandate of just Hmong and Somali and Spanish? I mean, there's dozens of languages we could print it in, but what they decided to do was make a compromise, and it passed almost unanimously out of the Senate. And any change would send this back into more discussion and a conference. And so I would appreciate a no vote on the Liebling amendment, just basically because we're giving the local agencies the right to put on whatever they want. In Mankato, you could have a whole different community of different languages than you might have in Duluth or International Falls or Fergus Falls, and all we would like to do is give the local agencies the right. And we got to give them some credit for brains. They know there could be lawsuits out there. They know there could be trouble. They're certainly not just going to print it in English if they've got 7 different languages around a college. I think they're going to print as many. There's absolutely no advantage for a local agency to print it in language, just one language, and throw it out there and not have anybody understand it. They don't want troubles or challenges or not guilty pleas or lawsuits. So I think we have to trust them for the responsibility to do what's right. And I ask you to oppose the amendment.
Further discussion to the amendment. The lady from Olmsted, Representative Norton.
Thank you, Mr. Speaker. And as you can see, I'm a co-author on this amendment, and I would encourage you to rethink this. I understand that the Senate had a compromise, but that's the Senate, and this is the House, and this is how it works. And I really feel like the way this will be interpreted and has in the past been interpreted can be done once and then shared among the law enforcement agencies and courts. So it isn't a burden on individual precincts or communities. It needn't be done 100 times. It can just be done once, and that information is shared. That happens through the Department of Education currently and can continue to happen throughout the state, particularly as we talk about consolidations and other types of reform. I have a large Somali population in my community, as do several others, and I would hope that even though you may not have a large Hispanic, Somali, or Hmong population, that you would do something that would support the folks that live in the districts that do. So, members, I would just ask that you think through this, that you continue with current law and add the word Somali so that we can impact and protect the constituents that live in some of our communities. Thank you.
The gentleman from Hennepin, Representative Benson.
Thank you, Mr. Speaker. Well, Representative Cornish, I'd like you to reconsider your position, and I'd just like to point out to the members here that we needn't get into a discussion, if that is it, about English only, because we have at least 2 groups here, the Hmong and the Somali, who have been admitted to America because they were refugees. That puts it in an entirely different situation. Now, some of you who are my age remember the Vietnamese War and the fact that we had thousands of Hmong who fought for the United States on our side against the communists, against the Viet Minh and others. And a qualification for coming to America and become citizens was not for them to learn the language. There are many in the Hmong community, even now, older generation, who still are struggling with the language. And the same is the case with the Somalis. Anyone who's been paying attention to current events in the Horn of Africa understand that one of the most violent, horrible places right now for human rights is Somalia. And many of the people who have come to Minnesota, and by the way, we have a very large community of Hmong and also Somalis in Minnesota, and they were admitted. And one of the great aspects of America and its history is that it has been a place of refuge. And we did not decide on refuge for groups who are being oppressed for religious reasons or for ethnic reasons or others, that they would be denied entrance. We have always held that their lives, protecting them, saving them from a horrendous situation came first. So we do have large numbers of people who have come to America as refugees, and we did not consider admitting them on the basis of language proficiency. So I would appeal to Representative Cornish to reconsider that we have a particular group, two particular groups here, whose language difficulties do intercede in this issue. Thank you, Mr. Speaker.
The gentleman from Dodge, Representative Quam.
Thank you, Mr. Speaker. Would Representative Norton yield to a question?
She will yield. The gentleman from Dodge.
Thank you, Mr. Speaker. Representative Norton, being familiar with Rochester and the school system, can you tell me approximately how many languages are spoken in the Rochester of students in the Rochester school system?
The lady from Olmsted.
Thank you, Mr. Speaker. Representative Quam, roughly 60 languages, give or take, depending on the year, though I will say the primary languages tend to be Hispanic, Hmong, and Somali as the leading. And you are correct. If you would like to say all languages, I'd support that amendment.
The gentleman from Dodge.
Thank you, Mr. Speaker. Thank you, Representative Norton. I was listening to this discussion, and I think it's appropriate for local communities to understand the diverse communities that they have within them. And I think that allowing the flexibility instead of dictating, because there may be some communities that do not have these. So I support the thought of not specifying some specific languages because we're leaving out, but I also realize that it'd be difficult for the state to print everything in 60 languages, and so I support the author's opinion on this amendment. Thank you.
The gentleman from Hennepin, Representative Carlson.
Yes, I'd like to comment in support of the amendment, and as many of you know, I'm a retired teacher, and the high school that I taught in Minneapolis had a very large English as a second language program. And our largest population happened to be Hmong, although we did have a number of different nationalities. But one of the differences that I want to point out, when I retired, we were starting to get a fair number, quite a large number of Eastern Europeans immigrating. And the fundamental difference between the populations like the Hmong and the Somali was that because of the Civil War and the war-torn countries that they were coming from and the camps, they hadn't had much of an educational experience, if any at all. And the Europeans that came in, mainly from Eastern Europe, had studied a second language. And that was a world of difference in terms of how fast they could accumulate a knowledge of the English language. Typically, if they were from Eastern Europe, they had been required, for example, in their school district to learn Russian. So if they were from Ukraine, the second language that they were required to learn was Russian. But the point is they knew how to study a foreign language. They had an educational background where many of those students who were coming out of those camps and so on had no or very little education. So I would encourage a yes vote on the amendment.
Further discussion. The gentleman from Blue Earth, Representative Cornish.
Mr. Speaker and members, I would still not change my position and ask for a no vote on the amendment. And the reason is all these organizations, Institute for Justice, criminal defense lawyers, public defenders, law enforcement, all agreed on this. It was a compromise in the Senate, and it really doesn't make a lot of sense to single out 3 languages when there's 60 of them and mandate that a local government has to do this. Leave it up to them. The wording in the bill goes on in that same paragraph to say this requirement does not preclude the appropriate agency from printing the notice in other languages in addition to English. So please leave it up to your local agency to figure out what their community is made up of and send out the proper notice. Thank you.
The lady from Olmsted, Representative Liebling.
Thank you, Mr. Speaker. Would Representative Cornish yield to a question?
Representative Cornish will yield. Representative Liebling.
Thank you, Mr. Speaker. Representative Cornish, does current law preclude local agencies from also giving notice in another language?
The gentleman from Blue Earth.
You're talking about this notice, does current law preclude? I'd have to look at that and see. I don't think they do preclude from giving laws, I guess I'm not understanding the question.
The lady from Olmsted.
Thank you, Mr. Speaker. Well, Representative Cornish, I think you answered it. The law does not preclude any local agency from giving as much notice as they want to. I mean, they can, they can write a haiku if they want to. Nothing's stopping them. So all this says, my amendment would put back these notices. It would be printed centrally. And if local agencies want to add a language because they think that, the person whose property they grabbed should get notice in a different language, they can do that. I don't think there's anything stopping them.
Discussion to the amendment. The lady from Hennepin, Representative Clark.
Thank you, Mr. Speaker. I'm wondering if the author would yield again to another question.
The gentleman from Blue Earth will yield. Representative Clark.
Thank you. I guess I'm wondering who's clamoring for what sounds like a kind of aggressively anti-immigrant language. You said it was a compromise, but where did this come from? I can tell you that people who would be watching this, who happen to be Hmong, Somali, or Spanish, are probably going to perceive this as kind of aggressively anti-immigrant. Is that something that a message we want to send out of here? I guess the question is, who's clamoring for this?
The gentleman from Blue Earth.
Mr. Speaker and Representative Clark, the groups that are asking for this were the different groups that formed the bill and came to the agreement, the criminal defense lawyers, the public defenders, the prosecuting attorneys, law enforcement. And I've just handed a note to say that the bill has the support of the immigrant advocacy groups for the bill, and they didn't think that this amendment on the floor right now is necessary.
The lady from Hennepin.
Thank you, Mr. Speaker. Would the author tell me the name of those immigrant advocacy groups? I happen to be connected and work with a lot of them. I've never had one single one talk to me about it. Can you tell me who you are saying is support and clamoring for this from the immigrant advocacy community?
The gentleman from Blue Earth, Representative Cornish.
Mr. Speaker and members, Representative Clark, it's the person from the Institute of Justice that testified at the committee table that sent in the note.
The lady from Hennepin.
Mr. Speaker, well, I thought I heard you say earlier that this was a compromise, and I know that sometimes when people are, given two bad choices, they might try to take one of the lesser. But I'm asking you, who's really pushing for this? Well, what's behind this need to take this language out? I mean, and maybe just for you, why do you really want to take out the ability of more people who are law enforcement officers, already have a challenge to work with in some cases, to be able to understand what's happening to them? Why would you want to make it harder for people to understand?
Is the lady from Hennepin asking the gentleman from Blue Earth to yield?
Mr. Speaker, yes, if I wasn't clear about that, I would request.
The gentleman will yield. Representative Cornish.
Just in common speak, as a chief of police, I would rather be left up to me and my agency what languages I think are in the community and not have to print 60 or 1 or 2 or 3. And I think these groups that are asking for this change and made the compromise didn't see the common sense when you have 60 languages out there to just put 3. And I think it's a relief of a mandate. Why not let the local community, I'm sure the immigrant population is different in International Falls and Fergus Falls and Redwood Falls and Minneapolis and St. Paul. Just let the local agency figure out who their community is made up of and which languages. And as far as me, I would hate to do anything that would make a not guilty plea or make somebody challenge or make a lawsuit. So if I thought there were certain languages out there, I'd sure put it on the bill and give it to him.
The lady from Hennepin.
Mr. Speaker, will the author yield again?
He will yield. The lady from Hennepin.
So, Mr. Speaker, I'm wondering, have you then ever in your law enforcement career done what you just said, which if you thought there were other languages needed out there, that you would ask that the appropriate language, the appropriate documents be printed in other languages? Is that something you've ever done?
The gentleman from Blue Earth.
Well, Representative Clark, Mr. Speaker, and Representative Clark, I've never had to, I guess, in the times that I'm thinking back. I come from a fairly small town of 2,500 people, and the people that we served the notices on, we knew were English speaking, and there was no need to put another language. If we would have found somebody that spoke real hard, broken English, or didn't understand, we thought we sure would have either supplied an interpreter or printed it in that language. So, and then I just got handed another note. These, I guess, my good friends at the ACLU have finally got on the same side of a bill that I am on, and they said they didn't think the amendment was necessary either. So, and the Human Rights Alliance. So it looks like, Representative Clark, there really isn't anybody out there supporting 3 languages. They want it off of there in relief of a mandate. So that's what I would wish you folks would do.
The lady from Hennepin.
Thank you, Mr. Speaker. Well, let me just tell you, there's a lot of suffering that happens when communities feel estranged from their law enforcement. They don't use the law enforcement in the way they'd like to, and law enforcement doesn't get to have some of the kind of witnesses that they want. And I think this is just another example of making it much more difficult for people to relate in certain parts of our state where we have at least these 3 communities in large proportions. You know, we're not talking about 60 different languages. There'd be nothing to prevent other languages from being added, but the majority of our immigrant communities that are in large numbers are these ones that are mentioned here. I just really don't understand why we'd want to make it harder, and I would guess that law enforcement wouldn't agree with that either. I have people in my district who are clamoring to have people of their own culture be able to become law enforcement officers because there aren't enough. There just aren't enough. And when people can't understand what the law is from a law enforcement officer, it can create a dangerous situation. This seems to me would be very positive, and I guess I start with my beginning statement, which to aggressively remove language that's been in state law that helps serve our immigrant community seems to me a very anti-immigrant move, and I would just ask us to think about it. If it's really the message that you want to send out there. Thank you.
Further discussion to the 326 amendment. The clerk will take the roll on the amendment. The clerk will close the roll. There being 51 ayes and 80 nays, the 326 amendment is not adopted. The clerk will give the bill its 3rd reading.
3rd reading, House File 1240 as amended.
3rd reading. Any further discussion? The gentleman from Scott, Representative Beard.
Mr. Speaker, members, thank you. Representative Cornish, I'm going to vote for this bill. But members, I want to just raise an issue here about forfeiture that came to my attention first about 3 or 4 years ago, working with some of my colleagues on the Legislative Audit Commission when the auditor brought us the absolute travesty that was going on with the gang strike force. Forfeiture was a word that was burned into my political consciousness as an overreach and abuse of government power. Lately, in the last year, I've become entangled in a couple of different cases that involve forfeiture involving drunk driving allegations. Members, not even convictions yet. And I want to tell you what we've done in this place to our citizens. Do you know it is possible to be acquitted, found innocent of a drunken driving charge and still lose your property? Do you know that's the case in this state? Do you know you can have your case continued for up to 2.5 years and still have your property sitting in an impound lot somewhere, seized by this government? And representatives, we just talked about languages for people to try to understand the forfeiture laws in this state. You can be an expert in the English language and not understand the forfeiture laws in this state. That's how bad this is. That's how bad this is, people. Representative Cornish, thank you for carrying this compromise bill. In my humble opinion, this is about the first step in a 1,000-mile journey
We have serious work to do in this legislature. Those of you, if we're fortunate enough to be reelected to come back here next year, if you would like my help, count me in. We need to do something to rectify a serious wrong with the forfeitures laws in Minnesota.
Further discussion to the bill. The gentleman from St. Louis, Representative Rukavina.
Well, Mr. Speaker, and Representative Beard, to you, because what you just said is a good point, and I brought it up in our caucus when we were discussing the last amendment, that I have constituents that can't understand in English why their vehicle's being taken away, because they haven't really been accused of anything yet. And we have, as a legislature, most of us been guilty of, just doing things that really aren't not only not fair, but it's getting to the point, members, where, when a police officer got to give you a ticket to make his house payment and the judge got to fine you to make a car payment or whatever, because we're running our system more and more off of fines and forfeitures, and really we do have to take a long, hard look at this. Representative Cornish, you in particular, because you know some of the injustices that are happening when people, the neighbor borrows their car, and they were supposed to know that 10 years ago they had a DWI, and all of a sudden their car's on the forfeiture block. They weren't driving it, they've never had a DWI, and their car is being forfeited. It just isn't right what's going on, and I thank you for bringing it up publicly.
Further discussion. The lady from Olmsted.
Thank you, Mr. Speaker. And Representative Beard, I just had to rise to say thank you for that. Because if you recall, a couple of years ago, I fought this fight, and I was pretty much alone, actually, in really trying to make some big changes. And I worked with the advocates who are working on this bill. And I've told people in committee, this brings the left and the right together. It really does, because this is about government grabbing people's stuff. And you know what, members? When government grabs your stuff, when the police agency takes your stuff, they get to keep 70% of the proceeds. Now, we like to think, and we are not, without impugning the integrity of any police officer, that is a built-in incentive to take people's property, and we shouldn't allow that incentive to be in law. We must change that. So I appreciate that. This bill is a compromise, but it does make some changes that are good, that move things in the right direction. And I agree, people don't understand the process. Lawyers don't understand the process. It's a tough process, and yeah, we need more than just putting some languages on a notice. But we need to make big changes, and I hope that some of us can work together to make that happen.
Further discussion to the bill. Further discussion to the bill is amended. Clerk will take the roll. Clerk will close the roll. Kiffmeyer votes aye. There being 130 ayes and 1 nay, the bill as amended is passed and its title agreed to. The next bill on the calendar for the day is House File 2046. The clerk will report the bill.
House File 2046 on the calendar for the day, an act relating to public safety.
The gentleman from Scott, Representative Woodard.
Thank you, Mr. Speaker. House File 2046 is a bill that would allow law enforcement to use the electronic database of civil commitment data that's currently housed at the Department of Human Services when doing background checks for the issuance of explosive permits. So currently, permits for explosives and permits for firearms require that there be a review of civil commitment data as part of the determination of whether or not an individual should receive a license or permit. And a recent change to the query permits
allows for the electronic access of the civil commitment data that's held at the Department of Human Services. So today when these checks are done, it's actually done without electronic access. It's done by a phone call or via a written report to the DHS. So this is a technical change to authorize law enforcement access to the additional records within DHS on the civil commitment. By authorizing this electronic access that we currently have for firearm permits and adding our explosive permits, will minimize disruptions and promote efficiency within the two agencies. Thank you, Mr. Speaker.
The clerk will give the bill its third reading.
Third reading, House File 2046.
Third reading. Discussion to the bill. The clerk will take the roll on the bill. Clerk will close the roll. There being 131 ayes and 0 nays, the bill is passed and it's titled agreed to. The next bill on the calendar for the day is House File 1834. The clerk will report the bill. 1835, excuse me, members. 1835.
House File 1835, the first engrossment, an act relating to public safety.
Representative Scott, to the bill.
Thank you, Mr. Speaker. Members, this is a simple bill. It simply expands the colors that a sheriff's vehicle or vehicles can be painted. Currently in statute, they have to be brown or white. This expands it to include black and gold. This will save our county sheriffs several $1,000s a year. And it also, there's an amendment that was added, is included in this bill, that would grandfather in any security vehicles that are painted gold. So that's the bill. Ask for your support.
The gentleman from Meeker, Representative Erdahl.
Thank you, Mr. Chairman. Members, I would like to support Representative Scott's bill. I received correspondence from the Sheriff of Wright County who thought this is a very good piece of legislation, or a fine piece of legislation, Mr. Speaker.
Further discussion? The clerk will give the bill its third reading.
Third reading, House File 1835.
Third reading. Is there any further discussion to the bill? The clerk will take the roll. Members, please vote. The clerk will close the roll. There being 120 ayes and 2 nays, House File 1835 is passed and it's titled agreed to. The next bill on the calendar for the day is House File 2246. The clerk will report the bill.
House File 2246 on the calendar for today, an act relating to public safety.
The gentleman from Isanti, Representative Daudt.
Thank you, Mr. Speaker and members. This is a bill that was brought to me by the Mille Lacs County Attorney's Office, who has noticed that they've had a few cases with a recurring problem where they've had some problems with appeals because of an error that occurred in the original statute from 2007. So what we're trying to do here is correct that error so that we're basically making sure that we don't have money being spent on frivolous appeals, and that the judges are able to sentence these as was intended by the statute. So basically all we're doing, not changing anything in the substance of the law, just correcting an error. So I believe that Representative Lesh also has an amendment that I would support to this bill.
There is an amendment at the desk. The clerk will report the amendment.
Lesh and others moving to amend House File 2246 as follows. The amendment is coded A1.
The gentleman from Ramsey, Representative Lesh.
Thank you, Mr. Speaker. Members, I did speak with Representative Daudt about this amendment. The reason I'm bringing it, and in cooperation with Representative Daudt, is because I was the author of the bill back in 2007 when we did this recodification. Clearly, something was missing, which means there were some letters that got missed in terms of the sections. And so enterprising attorneys pointed out these letters are wrong. In the statute, it doesn't refer to the crime I was convicted of, therefore I'm not guilty. That, of course, was not our intent when someone barrels their car into a family and has a blood alcohol intoxication level that makes it illegal. So we're correcting this mistake. But should there be any doubt, and in light of the fact that court clerks are terribly overworked, we've provided the legislative intent for them right here in the statute. Now, for those of you that have fundamental issues with legislative intent clauses like myself, there are two reasons why you should support this, other than just the fact that we have some victims of DWI crimes out there that would go uncompensated if, in fact, we were to fail to pass this. One is that this would not go in the code. It would appear only in the session laws itself. We wouldn't have legislative intent in the codification of the law. Second, we've done this before in 2001 in the Predatory Offenders Registry Law to prevent a similar situation of a miscitation and litigation. So this is to prevent further litigation. It's to clarify the law, and I'd ask for your support.
Discussion to the Lesh amendment. All in favor say aye. Opposed? The motion prevails. The clerk will give the bill its third reading.
Third reading, House File 2246 as amended.
Third reading. Any further discussion to the bill as amended? The clerk will take the roll. The clerk will close the roll. There being 130 ayes and 0 nays, the bill is passed as amended and the title agreed to. The next bill on the calendar for the day is House File 1043. The clerk will report the bill.
House File 1043, the first engrossment, an act relating to public safety.
The gentleman from St. Louis.
Thank you, Mr. Speaker and members. This bill has to do with car prowls and car tampering, and basically under present law, if you tamper or enter a vehicle without the owner's permission, it is a misdemeanor. Or if you are riding in a car that you know the driver doesn't have permission to drive, is a misdemeanor. And what this does, after 2 or more convictions or adjudications, it brings it up to a gross misdemeanor. And one of the reasons for this bill is many of the chiefs across the state have talked about car prowls being one of their major issues, particularly in Duluth in the metro area. And so this came through the Minnesota Chief of Police Association. And an example of the law not working is last year we had a guy who had 40 convictions for car tampering. And he saw it as a lucrative business because he wasn't getting charged with theft. He was getting misdemeanors and extensions of probation. And so this tries to correct some of that there's a cost for committing crimes, and I would ask for a green vote.
The clerk will give the bill its third reading.
Third reading, House File 1043.
Third reading. Discussion to the bill. The clerk will take the roll. The clerk will close the roll. There being 126 ayes and 3 nays, the bill is passed and its title agreed to. The gentleman from Washington, Representative Dean.
Mr. Speaker, I move the calendar of the day be continued.
The Majority Leader moves that the calendar for the day be continued. Any discussion? Hearing none, all in favor say aye. Aye. Opposed? The motion prevails. Motions and resolutions. There are copies of the non-controversial motions on the House desk and online. If there is no objection, we will take action on these motions first. Hearing no objections, the motions prevail.
Benson M. moves that House File 1813 be recalled from the Committee on Ways and Means and re-referred to the Committee on State Government Finance.
Representative Benson.
Thank you, Mr. Speaker. Members, we heard this bill and it was on its way to Ways and Means. We did get the fiscal note rather late, and I'd like for it to go back to the committee so that we can have another chance at talking with the Commissioner about how they arrived at that amount.
Any discussion? All in favor say aye. Aye. Opposed? The motion prevails.
Benson M. moves that House File 1816, now in the General Register, be referred to the Committee on Public Safety, Crime Prevention, Policy, and Finance.
The gentleman from Olmsted.
Thank you, Mr. Speaker and members. During the testimony in public safety, I did agree to make an amendment before it came to the floor to fix an issue that we found. Unfortunately, it was too complicated to do on the floor, and I'd like for it to go back to public safety so we can vet it properly and have it added.
Discussion? Hearing none, all in favor say aye. Aye. Opposed? Motion prevails.
Creasel moves that House File 2511 be recalled from the committee, from the Veteran Services Division and re-referred to the Committee on Environment, Energy, and Natural Resources Policy and Finance.
The gentleman from Washington.
Thank you, Mr. Speaker. That is my motion. I've spoken with both chairs. Would ask for your support. Thank you.
Any discussion? All in favor say aye. Aye. Opposed? Motion prevails.
That's it.
The gentleman from Washington, Representative Dean.
Mr. Speaker, I move that when the House adjourns today, it adjourns until 3 p.m. Thursday, March 1st, 2012.
Representative Dean moves that when the House adjourned today, it adjourns until 3 p.m. Thursday, March 1st, 2012. All those in favor say aye. Those opposed say no. Motion prevails. Representative Dean.
I move the House do now adjourn.
Oh, excuse me, before we do that, announcements.
Mr. Speaker.
I apologize. The gentleman from
Martin,
Representative Gauthier.
Very well. Thank you, Mr. Speaker. Yeah, the other day, Minority Leader Thiessen said that I wasn't hearing any DFL bills. So I went back. I wasn't in my chair. I'm sorry I couldn't answer you then. I went back and checked it out. Right now, we've heard one less DFL bill than we have Republican bill. And tomorrow we have 5 DFL bills and 1 Republican bill. So I think a little apology might be in line.
Any further announcements? The lady from Douglas. Any more announcements? The gentleman from Wright.
Thank you, Mr. Speaker. Point of personal privilege.
State your point of personal privilege.
Thank you, Mr. Speaker. I'd like to make an announcement that our good friend behind me, the whip, Mr. Bob Detmer's birthday is today. Oh, tomorrow. Oh, lousy. Thanks a lot for the wrong information. Tomorrow.
Okay. The gentleman from Washington, Representative Dean.
Move the House do now adjourn.
Representative Dean moves that the House do now adjourn. All those in favor say aye. Opposed say no. The motion prevails. The House stands adjourned until 3 p.m. Thursday, March 1st, 2012. We are adjourned.